Good morning, good afternoon, everybody. Hope you're all doing well, and thank you for joining us. Welcome, Matt. Being goofy as always. I gotta take my head off of there real quick, though. Looks a little much. There we go. So welcome. Obviously, you know the three of us, Ryan, Matt, and myself. Today we've brought Tyler with us, and I'll have him introduce himself in just a second. But today we're going to be talking about privacy legislation that we see coming, that is here at different state and federal levels. And really, I think the key takeaways here will really relate to how they're going to impact you as a channel partner and your downstream customers. They look a little different from other laws we have to comply with. There tends to be a lot more um, penalty you're stuck with, whether
Yeah,
or
say
not you
teeth.
are doing the right thing. Yeah, teeth. So Tyler, go ahead and introduce yourself. Let's know who you are.
Sure. Well, guys, thanks for having me first. I am PAX 8's lawyer, VP of Legal here at PAX 8. Um, I think the relevant part of my bio to this crew on this subject is that well before I was at PAX 8, I started my career doing counterterrorism work in the Middle East and Asia, and so my first encounters with privacy legislation, privacy rules, had much less to do with helping companies stay compliant and had much more to do with dealing with Edward Snowden fallout and intelligence and sort of defense use of personal data, those sorts of things. So I bring a view to this that's maybe a little bit different than your typical privacy professional in that space. And after doing my stint with the Govies there for a little while, came back here to Denver and did a lot of work in law firms doing general corporate stuff as well as setting up some privacy programs for some fairly large, well-known companies. Also did it for a Berkshire Hathaway company, and now I'm here at PAX 8 trying to help all of us understand what the landscape on privacy and cybersecurity really looks like for our end customers more than anybody else. So
Well,
that's, kind of me in a nutshell. What you got, Matt?
I'm not one to shy away from a question. First, I'll
Uh,
say hey to John Fry. That's my boy Blue. Love that guy. But I've been dying to ask this, and so I'm going to
all
ask
right.
it. So, in my mind, regulatory type penalties for cybersecurity failures. Okay, so let's
Uh-huh.
talk about the landscape as it was and as I see it now, and I just want the attorney's opinion on this.
All right.
So, as it used to sit, the regulatory challenge was not very big, right? Like if you look at Home Depot, 4.5 years in litigation, came out to be a fine smaller than their parking lot resurfacing budget for the eastern United States. Right, so it was like literally nothing. I mean, it was literally
Right.
just not going to do the parking lots this year,
Right.
and so you think about that. But the challenge was that there's a prosecutorial challenge. I don't really want to dig into that, but there's also this understanding that it's really can be met with just showing due care. It really can be met with just showing some of these basics of we tried, and you kind of get out of a lot of the risk of that. But when you start talking privacy legislation in mass, you actually
Mm-hmm.
start talking about if it happened, it's going to cost X,
Right.
right? And you start setting these very linear costs that you know are going to be whatever they are. And it's not about what your due care was. It's not about how well you did it in general. Now, I think
Right.
Connecticut's change here kind of makes that a little bit different. But would you say that in general, privacy laws are much more about if you fail, you're going to pay X? It's all about limiting the risk by limiting how much that blast radius is, right? 3 exposures instead of 3 million, or
Yeah.
that kind of
I
thing.
mean, that's part of it. That's part of it on the privacy legislation front. Let's let's level set a little bit though before I dive in deep into your question there, Matt. So first of all, because I'm a lawyer, I have to do the caveat,
I
right?
love it. No, you wouldn't
Yeah.
be a lawyer
Right,
if you
right,
didn't. Yeah, yeah.
right. Get your own legal advice in the jurisdiction where you're operating. And that's
Sure.
largely, guys, because uh, we have 50 different laws in the US. We don't have federal law on
National
privacy to
legislation.
speak of.
Mm-mm.
Right.
Right.
So we've got it in a few verticals, a few areas like HIPAA, for example, that everybody's
Yep.
familiar with. We can talk about that if we want to. Um, but for the most part, the privacy rules and the teeth that you're talking about there, Matt, are going to be implemented at the state level, and it's going to vary state to state,
Yeah.
what your penalties look like. I'll just take data breach notifications, for example, right? Like I was at a place a few years ago. There was a data breach caused by one of our vendors, and it took the whole legal department several, like we employed every resource we had just to figure out what our data breach notifications were and what the penalties were for not notifying folks.
Right.
And those differ from state to state. It could be no penalty, it could be enforced by the state, or what we're seeing a lot
Lawsuit.
more
Yeah.
are private rights of action.
Yeah, like California.
California's got a private right of action. Colorado and Virginia do not, but there's privacy legislation in committees state by state that do have it. I think last year, several bills in state houses, state senates failed because they included a private right of action.
Yeah, I could see the chaos of that.
Right.
Right.
So in a sense, you can know that the GDPR in Europe is actually the easiest to figure out because it's a sliding scale depending on how bad of a boy you've been and how indefensible your privacy and security practices have been. You can pay up to 4% of global turnover as a fine to the European Union.
Yeah.
So that's just.
I'm glad you said indefensible because you just pulled my string a little bit there, Tyler. I've been on this rant that an MSP's job is not to protect their client's network. An MSP's job is to be defensible in the actions they chose to take to be able to deliver what they promised to deliver to their client. And so it really comes down to defensibility, right? In the sense that they need to be able to say, I'm referencing an external framework. This is why I did what I did. This is why I changed. This is how I iterated. This is how I can prove I was actually doing those things. Like a lot of the privacy legislation comes down to defensibility. Yeah. Right. In my opinion, and having that proof ready that shows you're doing the actions.
Yeah. And that's broadly right, Matt. I mean, there are going to be something. It's going to depend on enforcement agency to enforcement agency.
Sure.
And, what a cop had for breakfast that day. As far as, what's defensible and what's not.
It's like a speeding ticket,
Yeah, sort of.
You're going to get the ticket.
Right. Well, and like a speeding ticket, the trick is not to give the cop a reason to follow you. So just be defensible. Do your thing. Do your diligence. Make sure that you're doing the best that you can from a reasonability perspective. And you'll get most of the time to where you want to be. And that doesn't mean there won't be bumps in the road. There will be stuff that pops up. There will be things that make you stay up at night. There will be days where you think you're going to have a heart attack because, something went wrong. Yeah. Ultimately, though, as long as you're trying to do the right thing and protect privacy, as long as you've got privacy and security kind of built into your DNA about what you're trying to do, things like data minimization. Right, like you only take in as much data as you need to provide the services that you need to provide.
Yeah, ice cream store doesn't need my social, right? Like I don't need to give my social to buy an ice cream cone. Yeah,
that's exactly right. Right, you don't need, and that's sort of where privacy legislation, I think, generally is going. And we can talk about this a little bit later on. I think there's 5 or 6 areas that we can expect state level privacy laws to focus on. But as far as your original question goes, Matt, if you're in a state where its enforcement only takes place at the state agencies level, which today is Colorado and Virginia, right? Then you can be pretty sure what your penalty set's going to look like, what your impact on the bottom line is going to look like. That doesn't, however, mean that there won't be reputational effects, which are probably more important than an actual fine from any sort of data protection authority.
I think one interesting angle to approach is if there's not a privacy law setting out specific penalties that may be imposed by an agency, there's always the risk of civil action, right?
Yep.
If you leak enough people and enough people call a lawyer, you have a class action on your hands, right? So there's still that civil angle.
Well, especially in the states that have right of recourse for the citizen, right? And has that space. And I think one of the things that gets a little bit histrionic there is that when you start thinking about what it would take to prosecute, or I guess not prosecute in this case, but to litigate a lawsuit around privacy, the 12 people sitting in a box have a challenge of understanding the terms and nomenclature, even more so than medical, right? In medical cases, you have this large amount of education that has to happen for the jurors to understand some of those terminologies. Now take that to whether or not you had active filtering or passive filtering and what those delineations were. And, you start getting into that. And so when I talk about defensibility, in my mind, it's about building such a body of evidence of the work that you're doing, right? The logging, the proof, the processes and procedures you do to validate that the processes and procedures are followed. Those things that show a healthy, operational maturity around those services, I think can overwhelm some of the prosecutorial challenges of understanding the actual tech, right? And so it's kind of this, in my mind, if an MSP can bury the conversation in, yes, I have these standards, I update them 3 times a year, here's where I can show the last changes we made, here's where those changes were implemented in your systems, here's where it's starting to understand that we're going to lose, which goes back to Tyler's point. It comes to, why should I collect that information? If I don't need that, should I have it as part of the data set that could be compromised? But it also means we have to educate our constituency about that. Right. And part of that as an MSP, as a job, and what I find my job to be, is educating constituency and educating people to say, hey, client, maybe you shouldn't collect that if you're an ice cream company from your people. And if you do, maybe you should enclave that differently. And you shouldn't have just one giant S drive. And, so much of security is thought of as tools.
Yeah.
But in reality, it's processes and procedures and intent. And I think privacy legislation, in my mind, is going to go a long way, whether it's state-driven or if it's chaotic and driven by me suing you, is going to go a long way to at least building some of the muscle flexing necessary of doing those things to get in that cadence and be a participatory sport. So.
2 things. Wanted to shout out those in Florida, fellow USF grad here, but also wanted to kind of pick your guys' brain on, my mind goes straight to the Yoda moniker, right? Like, do or do not, there is no try. And the client's going to say the same thing to you, right? There is no try.
Lots of try.
You still allowed me to be vulnerable, or, hey, Matt Lee, you created this killer checklist of stuff. I don't really get what a lot of it is, and now I've been compromised. How do you create a defensible moniker there, right? Because in the client's eyes, it's you didn't help me or you didn't protect me.
I'll go first.
I'm not a lawyer over here.
I'll go first so Tyler has something to correct. I think it's about perception building ahead of time. I think the challenge is we speak about this stupidly. We act like, and this comes paradoxically from all the vendors too, I love them to death, but saying we'll stop all malware is a lie.
Yeah,
it's a lie. It's not possible. And so I think part of the way I was successful was just setting the expectation that you're going to lose yards. Right? In a football game, if you're a defensive coach and you step out and say, I'm never going to lose a yard, you're an idiot. You're going to lose a yard. It's about controlling how many downs. It's about controlling the yards and field position. It's about those things. And so we need to think more like a game, more like a sport that has no end, and less like this finality of I'm going to stop everything. So in my opinion, it's about the positioning, and I think it's about documenting that positioning ahead of time to set expectations of there may be compromise. In fact, I need your help to know where the data is so we can make sure and limit that and control the blast radius and have educated decisions on should Johnny have access to that data in accounting if he's not in accounting, and should, right? And so that's what I think Tyler gets to correct. So that's my take on it.
There's nothing there to correct, Matt. I think you're absolutely right. It is important for us, I think, to draw a distinction between security on the one hand, right, and data privacy, especially data privacy legislation on the other. Those are 2 different things.
True story.
So a lot of data privacy legislation is less about there's been a breach and my data has gotten out. That's part of it.
Sure. But
it's more about which son of a bitch has access to my data and what are they doing with it?
Yeah.
Right.
That's really kind of where we are. Like, who's selling my data to whom? What are they getting it?
It's not Meta. They don't ever sell data.
Never. Why am I getting this creepy ad, that tells me that somebody, one of the elves in the internet, knows that I was looking for a gift for my wife for her birthday?
Oh, yeah.
Right? Like, that stuff, that's what creeps people out. Even more that, like, we know there's going to be bad guys who try to do bad stuff. And that's their fault. That's not necessarily anybody else's, fault.
Yeah.
Bad guys are going to do what bad guys are going to do, and so we can put measures in place to try to make that harder for them, just like you were talking about, Matt. Right? Like we're playing defense. You're a defensive coordinator, and you're just trying to keep the score as low as you can.
Yep.
That's really what you're talking about there. From a privacy perspective, I would look at that, at your privacy angle, as part of your overall security posture, right?
Sure.
And privacy legislation is sometimes about the cybersecurity, the security element. For example, the GDPR requires some security protocols, right? And some privacy legislation does too. But really, they're more focused on, let's just minimize the amount of data that is available to be breached in the first place.
Yeah.
That's
but
they're concerned about.
It also creates, and Dom, I kind of been just I haven't gotten attorney time, and it usually costs me 3 times this to have this conversation with him. So, but
at least,
what I would say though and argue is I don't think security is a separate thing. I think by us defining security as a separate thing is a problem. Like I think it's just like, do I talk about windshield wiping class? Do I talk about seat belting class? No, it's just part of driving a car, right? But those are security measures meant to protect us. And so I think, though, what privacy will drive, because of some of those data reduction capabilities, like Dom wants to delete his data under GDPR, Dom has to be able to delete his data, right? And I'm summarizing and maybe a little bit off, but to some extent. And so the point is that means you have to create systems that allow me to even know where that data is, that allow me to even decide how I would want to scrub that data, which means it's forcing people to be more robust and a little bit more mature around those data practices that lends itself to security as well, right? Like, so.
No, it's all part of a whole, and it's pieces of a whole, and they are mutually reinforcing.
Yes.
It helps a good spiral instead of a spiral down into, just
right. It's a build up. Yeah.
It's a spiral up. That's the effort. You're right.
And I think from a security perspective, there's a difference, obviously, in selling data. And I guess we don't really have to go there, but obviously, look, plenty of companies sell data. You got something for free. You're the product. We all know this.
Yeah, right.
There's a difference between, hey, I didn't pay attention to the privacy policy that literally nobody ever reads. And I didn't know you were going to sell my data. And I think privacy laws really help that by limiting the ability, because I've seen companies write privacy policies that if you printed it, it'd probably be 15 pages of junk. And somewhere in there, it's like, oh yeah, we might sell this to someone,
You know what, though? There's a reason for that, Dom. Do you want to know what the reason is?
Yeah. I do.
Okay. We don't have federal privacy rules. And so in order to avoid
the state,
if you're a resident of da.
Yeah.
Right. And so and partially one of the only federal tools that we have is the Federal Trade Commission, right? The FTC can enforce, enforce rules against false and misleading trade practices.
Which we just saw, Tyler, on Tuesday last week, right? The DOJ came out and said, I'm going to start suing MSSPs and MSPs under that clause, right? Under the Federal Trade Commission false practices. Yeah.
Right.
Brilliant.
And what they're looking for there is really just the only thing they can do, the only peg that they have to hang one of those suits on is basically, did you do what you said you would do? Right. And did you tell everybody what you would be doing with their data? If you tell people, and you can just bury it in those 150 pages of your privacy policy if you're going to be that guy.
Right.
But as long as you've said, I'm going to sell your data, and then you sell their data, well, then that's okay. But if you've said in that policy, I'm not going to sell your data, but then you do, you've got a problem on your hands. So it's basically just do what you say and say what you do is pretty much what the FTC is looking for. That's really where we are, which is why it gets tough when people are saying we're the most secure and we'll stop every data breach and we're going to do all the. That's where you can run into trouble. Is, are you representing
exactly
that you don't or can't do?
Right.
That's when you get into trouble.
Well, that's what we see in cyber services all the time.
we've I mean, this is me not being a lawyer or super technical. South Park had an episode on this, 11 years ago with the iTunes agreement. Why aren't people
Yes.
Yep.
reading?
Yeah.
And it's 11 years later, and we're still in this same revolving loop of like, I don't read it, I click yes to agree, I utilize the service without even knowing what you're doing with my data. It's
Yeah.
unreal.
Well, you just pulled my string on this because I think there should be limits on what can be written in those agreements. I don't think that EULAs can just hold risk off as if it's something that someone else owns. And I think that the shared responsibility models should apply in the EULAs too. And I think there are things that, sorry, Tyler, but I just think that the attorneys actually create some of this ability to not give a shit about doing your part, right? I mean, how many great software agreements protect shitty software companies from the risk that they've created? And it just generates the ability to have complacency. And I just wish that there wasn't the ability to transfer so much of this risk in such a blind EULA privacy agreement, or otherwise, right? But yeah, sorry, get me going on that one. It bothers me.
Well, I think when I was running my MSP, I had a great business lawyer, and when I was working with her, I said, obviously, I want our agreements to be comprehensive, but I also want them to be readable. And it kind of took her aback a little bit. She's like, "Really?"
Agreed,
like,
Edward.
yeah, I'm gonna sit with the phone and read them through this so that there's no surprises if we turn off their email after they don't pay us, right? I want them to really understand what they're getting into. And I'm not trying to toot my own horn so much as say that should be the attitude. Like if I'm going to go sell you something and I'm going to enter into a contract with you, I want you to understand what you're signing up for. Because even if, we have to go to court and I win all day long because my agreement's rock solid and you didn't read it, I still think it makes me the asshole, right? If there was no way you were ever going to understand that agreement.
Yeah.
And on the same token, I always had her review any agreement I was going to sign. Now, that's obviously not available to everyone in a convenient fashion, but I had counsel review anything I was going to sign ever, except for a check, right? So
Edward nailed it in the chat. Edward's got it spot on.
Yep, 100%.
Yeah.
By the way, welcome all the guests that are here. I'm surprised how many are here. It's awesome. It's very cool.
Yeah,
Canada
awesome.
And Florida.
Unfortunately, Restream doesn't do a good job counting. I think a lot of folks are coming on LinkedIn and it doesn't count those, so I can't see the attendee count right now. But,
yeah. But yes, they will click on literally anything if they need it at the moment.
They will.
And those are binding clicks. I mean, in a lot of ways, right? Like we used to redline with our contracts, and sometimes that meant I had to literally not start the service because they embedded it. I mean, look at Proofpoint's a great example. You literally can't start in their console until you click through the agreement, and you have those things where. Does that mean you have to operationally pause while you negotiate agreements, right? And what that EULA is actually going to look like? And then what happens when you have one that you signed and yet you have this other one you agreed to digitally? And, I find a lot of the it's a little Wild West around those things. And maybe, Tyler, you can set that a little different for me, but I just feel like there's just anything flies.
It's I'll tell you what, guys, it is a lot of sort of the behavior is an attempt to try to cover any potential risks that I might have. So it's one thing if you're negotiating an agreement, a true agreement amongst equals, right? Where you can go back and forth and there's a real negotiation there. Then Dom, I think you are exactly right. You want to have that process of negotiation. It is actually really useful because you're putting out all of the potential issues out there up front.
Yeah.
How are we going to deal with this if that happens? How are we going to deal with A if B? Those sorts of things. Those are good conversations to have. Yeah. And they typically only occur when the power balance is equal or it gets close to being equal. When we're looking at purchasing software, for example, from a vendor, they have purchased teams of people like me to protect them.
Not as good as you though, Tyler. Not near as good as you.
Believe it or not, almost as good as me.
Oh, that's crazy. That's craziness.
But they've got just teams of us, and that's what we do all day, every day. It's just write these things out, have it structured so that any potential problem that happens, my
Has
side
something
wins.
written. Yeah.
Right. And if you want the thing that I'm selling, you're going to agree to it, and I'm not changing it. And if you don't want what I'm selling, then you don't have to agree to this, and I won't get that sale. And
Yeah.
that's basically the attitude. And the only way you're going to stop that is with some other party in the mix
Yeah.
to equalize the power imbalance, which means most of the time government. So I'm going to sound like a commie for a second, right? But that basically is what happens. You have
Well,
to have government intervention in order to equalize that playing field.
Right.
and that's where I was going with it, right? I think in that sense of if the contract has some leveling quality, something that says you can't do this in a contract, you can do this in a contract for this, right? That's the government stepping in, right? In my mind of saying, yeah, but these things can't be completely unbalanced and unfair because you often do have a massive power imbalance. I only was able to start redlining agreements when I was about to buy $3 million worth of software from somebody.
That's right.
Well, when I
Right.
became a percent and something, but before that, they told me go chuck rocks, right? Like
Uh-huh.
I did not. So I think you
And in the
very
consumer
accurately
space-
described power imbalance.
Yeah, and in the consumer space, like you cannot sign up for an Apple account and then be like,
Yeah.
I had my friend who's a lawyer look at this, and what are you going to do? It's
You're
never
not gonna-
ever going to happen. But
You're
there's
not going to do
definitely-
anything.
Yeah.
right, right. But there's definitely wins. I think that we're starting to see in small chunks, right? The whole, hey, your privacy page needs to be very clearly displayed on the front page and things like that. And I think
Sure.
we'll see that ratchet up where you need to summarize what's going on in your policies, and you need to really make it understandable to not a lawyer. And that's the challenge. Is you went to school for a long time to get a JD and become a lawyer and pass the bar.
That's right.
You can read these things and it's natural to you. Anytime I go in, I have to come to you and be like, hey man, what's this mean? And that's the problem, or part of the problem.
You know what's
By the way,
interesting
Dom,
about that
it's still a
statement?
pain in the ass for me, right? Like it's still to read that stuff.
Right.
You know what's interesting about that statement is I can destroy a business just as fast, if not faster, than the attorney, and yet I have no licensure. I have no standard of care. I have no barrier to entry. I have no validation. I know what I'm talking about.
It goes
Right?
back to
Our
the
industry's
barbershop.
broken. Yeah, the barbershop conversation.
Yeah. Well, guys, and this is where I do think there's some spaces in, as we're talking about privacy legislation, there's a couple areas that folks are pushing on that I think are worth sort of explaining to our audience. One of them is in data collection and sharing, right? Like there are increasingly rules about how you collect data, who you share it with. For example, California's rule on the sale of data is pretty broad. It basically means if you're giving data to any third party, you've sold that data under their law, right? So that's useful. You've also got what does our default setting look like? Do you have to go into your settings and undo all the stuff that they've already set? Or is our default setting, you're not sharing anything, and I have to go in and explicitly give you permission to
And you know
share
which one
data?
that is. That's always going to be the former, not the latter in most companies. Like,
Well, right, and data minimization, right? Like rules about what data are you collecting, how are you collecting it. I also think that as these data privacy regulations are moving forward, rules about not discriminating against individuals or businesses who elect not to share their data. Because that genie is out of the bottle, guys.
yeah.
Folks know that a big part of the economy is driven by data sharing, and big data makes a big difference, right?
Yep.
So smart folks will try to, if you don't want to share your data with them, well, then you're not getting the best features, and you're not getting X, and you're not getting Y, and you can't do this.
It's the
Or
whole
like
premise of
throttling.
the loyalty program, right? Like if I don't give up my phone number to King Supers, I don't get like the card discount, the super card.
I just
discount.
use 8675309.
Oh, there you
Yeah.
go. Man, you get so many gas points all day. It's just
I know,
whoever
right?
cleans
It's
it
crazy.
first, right?
Yeah.
Yeah.
Poor Jenny is just deluged with spam from you.
Hey,
More-
I wanted
More
to touch on
grocery
this
points than
one.
what to do with.
So, how many MSPs walk their clients through agreements being made for a specific client? Like, I didn't even think about this, but think of what Adobe, when you go download that software, who's being bound? Like, who literally clicked it? Is it under the auspices of the person that's being bound by that agreement? Like, that gets into some interesting legal questions, right? Like,
typically the customer has delegated their administrative rights to the MSP, and therefore the MSP is doing it on their behalf, theoretically with their knowledge, and Adobe's not changing anything anyway. So if the customer wants to get an Adobe license, they're going to agree to the same EULA no matter who is providing it to them.
So it's like transferable in the risk because we'd have had to accept it either way to use it, is the point.
It's the SRDH school of legal risk, the shit rolls downhill school of legal risk.
All right, I'm using SRDH
I like
from
that
now
one.
on.
Yeah,
I was in my head going state regulation. What?
Yeah, no.
Your Honor, I'd like to invoke the SRHD RDH rule, if you don't mind.
That's solid though, and in our agreements, if you purchase like our Stellar IT service, which was our managed service, we did cross-reference. Hey, you're getting Microsoft out of this. Here's the MCA and things like that. They were part of our core service. But if they came to us for a license of like, I don't know, we sold random software in a marketplace, like Foxit, I guess is an example. It's a good point because I didn't go over the Foxit license. Like it was just like, no, it's $99. There you go. So that's,
and it doesn't. Honestly, Dom, it doesn't do you a whole lot of good. All the software licenses are going to be pretty much the same, which is basically we guarantee nothing. You're buying this as is, all faults, no warranties, no nothing. If it breaks, we're not sorry.
But that's what's wrong with us. Like I'm getting back on my damn soapbox, right? But that's what allows people to have shit technical debt, follow and build up behind the next new product, right? Like that is what's wrong, and that's the kind of limitations I mean shouldn't exist. You shouldn't be able to get complete hold harmlesses when you're building a SaaS product that can't even get CVEs, that's all proprietary, that you can't, like, just blows my mind. Anyway, sorry. SRDH is the biggest nugget so far. I got to be honest. I stood Brian up for lunch the other day, and I got to apologize to him publicly. Brian, I love you, boo. And I forgot that the one was moving wasn't the one for lunch. And so I did delete that, and I owe you lunch now. I just wanted to be very public about that. I apologize.
That's big of you, Matt. That's big of you.
Well, it's better to tell on yourself.
That's right.
So this is an interesting one too. Is Luke's interested in which agreement takes precedence, the software agreement or the MSP agreement? I would think they're not the same.
They're not the same.
Two different agreements, right? So none takes precedence. Yeah.
And different scopes too, right? Like very different scopes.
Yeah. Right. The MSP agreement is usually a services agreement, and the software license is separate. And the service may include provisioning that software license for you, but the end customer is always ultimately bound.
Unless it's let's call them microloft contract, and then in which case the MSP's bound. And did I say that out loud? I didn't mean to say that outside. I'm being facetious. I digress. That's going to cost me. I just saw the handler make a checkbox in the book. So
yeah.
Taking notes over here.
You asked a 5-year-old question. I'm not sure I follow.
I think it's this one here. I would imagine the answer is seek your counsel, but
so we all encompassing term. Yeah, I mean, so for real, guys, this is one of those things where like the rules are different state to state. Look, and it's tough. I'll just be honest with everybody. It's tough for me because I'm PAX 8's lawyer. I'm not your lawyer, so I've got to be able to sort of do that. But it kind of doesn't matter what the size of your client group. What it is, like if folks are signing the terms of service, the end user license agreement is always going to govern what anybody's relationship is to that software vendor and how they use that data and where they can store it and where they're moving it. It's important to know, like this is primarily an American audience here from what I gather, right? Americans and Canadians.
Should be.
So our system is much less developed than the European system, at least from a privacy perspective. I mean, it just
nascent at best.
Yeah. The Europeans, I think, do a pretty good job in that space. They've tried to strike as good a balance as I think you probably can. It's rough. It's still legislation, right? It's still a blunt instrument. It's not perfect by any means. And they are pressuring the United States to move in that direction. And they'll keep pushing and they'll keep
Me
pushing.
personally, I would very much back the idea of the U.S. having federal level legislation.
Oh my God, that would make
similar to
things so
GDPR,
much
'cause
easier.
It would be so much easier if it was the same across the board. Then everyone understands what the North Star is. Everyone understands what the risks are, and you could start to build services that serve everyone. And that's if there's 50 different rules. Like I can't imagine being in your position, Tyler, where we do business in all 50 states and internationally. That's so many different sets of rules that we have to deal with, and that's what's crazy about our system in particular is that there's just no standard. The standard is where you happen to be standing. You know.
Question for Matt and Dom: as ex-MSPs, what would you do when you had clients that were multi-state, across state lines, or in a state like California or Mass, and then in a state like North Dakota as well? Are you guys creating different TOCs for each of those?
It's going to be kind of like Tyler's answer about the privacy conversation. Our agreements are just freaking massive, right? Like they have what's acceptable, what parts are struck in this state, what parts aren't struck in that state. Here's the parts that are applicable in these. Yeah, I think, and then the other side of that coin, though, also for me, was depended on the level of maturity I was at the time. There was a time where we just had a stupid agreement that hadn't been rewritten in 19 years and had the same damn cross-out language, and and then there's a time where it's a very vetted agreement and it's been validated across many states for its legal aspect. So I would say it varies, but yeah.
And Ryan, to help answer that a little bit from the lawyer's perspective that would be advising these guys, I would say you got two options. I can either draft you that crazy big caveated one that Matt's talking about that's super long that only I understand and everybody else is going to have to come to me to figure out what it means. But it gives you the widest latitude that you can have to do what you need to do and protects you the most. Or I can say, here are the rules that are the most restrictive to you. So if you're operating in California and Nevada, for example, right, or California, Nevada, and Arizona, I could say we can make this so that if somebody's in Nevada, then this. If somebody's in Arizona, then that. Or I can just say, look, here are the standards in California, and we're just going to apply it to everybody. That's actually the way that we try to do it at PAX 8, is to just say, like, hey, what's
here's the jurisdiction. Yeah.
What's our highest and best standard? What's going to be best for everybody? And let's just do that. Let's just do the best practice. I think that's typically the best way to go for several reasons, right? Like, and mostly just because you're doing the right thing, and we're all human beings working with each other. So let's just do the right thing for the right reason. It makes it simple and easy.
If you're doing best practices across the board, no matter what, then that SRDH component doesn't really play, right?
I am very happy I learned SRDH. That's so good.
That's a good one.
All right.
So Edward, you made an interesting comment about those MSPs that say we don't need complex agreements or in the wild, wild west.
I don't know.
I would argue that our agreement wasn't complex at my MSP. I mean, it was relatively comprehensive. We only did business in Colorado. I guess I'll admit that we have one customer that did business in another state. We sort of just pretended it was fine. But, it was a pretty simple agreement. I would say with the proposal and the scope and the MSA put together, it's like 6 pages, very as easy as possible as we could get it to understand. So I don't know if I'd call it complex. But Tyler, I'm not sure how you'd weigh in there.
Yeah, I think I would make a distinction between complex and comprehensive. You want a comprehensive agreement that covers everything that needs to be covered. Most of the time when somebody's creating a complex agreement, it's because they're trying to confuse things. That there is something that's pointed somewhere. I would just point folks to say, like, if anybody's ever read, for example, like an Amazon customer agreement or the AWS customer agreement or something, right? It points you all over the place. And part of that is because they're such a huge company. They're trying to just have one agreement that covers everything under all circumstances. And some of it is, this allows us to not have people will get frustrated and stop reading it before they try to understand what they're signing.
I knew this was going to be the one you were going to pop up. Edward, when you see those that don't have any agreement at all, I'd do what Poutine Master up here is saying. Get out. No,
Handshakes
that's
do not
crazy.
count in the court of law. Like,
Yeah.
that's-
Yeah.
It's so
Well,
tough. Like
yeah,
you
it's rough.
can't. You have nothing. You have nothing. Nothing's written down. You can have verbal agreement. It makes life so much more difficult. Yeah, run fast.
Once he
Run
said,
far.
she said, right? It's like,
Yeah.
no, we said that. No, we said that. No, and it.
Well, it just makes the litigation costs go way up. Any time that you're in a dispute, if you make it into a courtroom, you have already lost.
Yes.
Already. Like,
Yes.
everybody
Yeah,
is
you've already lost. That's why you're litigating it at this
Right.
stage, right? Like,
That's
and
right.
even then, those 12 people sitting across from you, likelihood they understand what's even being discussed is a crapshoot.
Yeah.
I think yeah. All right. I think that Dom and Tyler, this was, gosh, what a great conversation. I would expect the bill, Tyler. I know that's coming, but
Yeah. Oh,
you know.
definitely. Yeah.
We pay in malted beverages, just so you know. So
Yes. Fermented for sure.
I was under the impression this was pro bono work, Tyler.
Never.
You know, the meaning of life is there's no such thing as a free lunch. Thank you all for being here.
yeah,
So,
thank you, Tyler, for joining us, and thanks everyone for joining us. Thanks for the great engagement.
Yeah, it's
and
been
I'm
awesome.
sure we'll talk soon when the next incident drops. Thanks.
Yeah.
everyone.
It'll be soon. It is a
Tons of
Friday.
good stuff. Tons of great questions. Love it.
See you.
Awesome. See you guys.
Bye, guys.